We are on the record calling 21170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right, Mr. Hurst.
We attempted to do discovery anyways.
Mr. Hurst, did you refuse to accept the mail?
All right, guys, here's where the chaos officially begins. This man walks into court acting like he can activate some magical force field by saying the word freeze. Bro thinks he's in a superhero movie, not an actual courtroom. And then, this is the best part, he marks his discovery packet with a neon edible highlighter, like that's somehow going to avoid his legal problems. The judge is staring at him like, are you serious right now? Because honestly, you'd have to be having a moment to believe writing, I don't accept this, on an official document actually makes it disappear. This is the kind of logic you only find in cartoon universes. The judge hasn't even started roasting him yet, but you can already see the disbelief building. From the first 5 seconds, you know this hearing is about to become a full comedy episode. This guy is rewriting courtroom history, just not in the way he thinks.
One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor,
you don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not.
Now in clip 2, the disaster somehow gets even better. Our sovereign citizen hero decides to refuse his discovery packet like it's a spam brochure someone handed him on the street. The judge is baffled because rejecting your discovery packet is basically the legal equivalent of going into a boxing match blindfolded. This packet literally contains the allegations, the evidence, and the entire roadmap of what's coming in trial. And my guy just said, nope, don't want it. This is self-sabotage on a professional level. The judge calmly explains what he just risked, but the defendant is stuck in his own imaginary rulebook, convinced that refusing paperwork somehow gives him the upper hand. Spoiler, it doesn't. This clip perfectly showcases the beautiful collision between courtroom reality and sovereign citizen fantasy. The judge's face says everything. He knows this trial is going to be one long comedy show.
They just coming with these allegations. I'm trying to see and verify if it is. Then when they called me the first time, they should have sent out verified documents stating that the original creditor and who it was, and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already
excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
You, Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
Talking.
This is not a clown show.
Oh my goodness.
One at a time.
I can finish my statement.
You will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr. Hurst.
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute
I don't
you.
even understand what's going on.
Clip 3 is where the judge finally snaps, politely but brutally. After hearing layers of nonsense, he basically questions whether the defendant even has the ability to tie his own shoes without accidentally eating a sock. And honestly, fair, because the arguments coming out of this man's mouth feel like they were crafted using crayons and wishful thinking. The courtroom energy shifts instantly. You can feel everyone silently trying not to laugh. This is elite-level judicial roasting. The defendant thinks he's delivering deep legal wisdom, but he's actually showcasing the world's most spectacular misunderstanding of how law works. Every sentence, he says, digs him deeper into confusion, and the judge is done pretending otherwise. This clip is short, sharp, and absolutely savage, one of those iconic roast moments people replay just to appreciate the delivery.
And I will let Ms. Strickhurst say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickhurst, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refuse the packet, because I don't know if they're trying to contract with.
Clip 4 hits with pure financial truth. The judge tells him very calmly that sovereign citizens are financial black holes. Translation: no sane person with functioning math skills would willingly enter into a contract with any of them. This is courtroom poetry. Sovereign citizens love throwing around contract terms, commercial law buzzwords, and imaginary loopholes, but the judge shuts it down with one sentence. And the best part, the defendant has no comeback. Zero. Because how do you argue against being called a bad investment? This is peak judicial sarcasm delivered with a straight face. The clip becomes even funnier when you realize the judge isn't even angry. He's just casually roasting this man's entire ideology. If courtroom burn moments were an Olympic sport, this one would win gold.
I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you.
Here we go. Clip 5 is pure comedy gold. The judge basically says, if you want to ruin your own life, go ahead. That's when you know the situation is beyond saving. The paint chip line? Legendary. It's the courtroom's version of a knockout punch. The judge is essentially telling him, if you want to buffet-style sabotage your own future, be my guest. And Judge Robinson being mentioned? Beautiful. Because you can almost see Robinson laughing in slow motion at the nonsense unfolding in front of him. This clip is that perfect blend of sarcasm, frustration, and entertainment you only get when a sovereign citizen shows up thinking they've cracked the legal matrix. The judge isn't angry, he's amused. And honestly, so is everyone watching.
Question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she have to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the packet. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you, I got a question. Should they have sent me something before they send me this package since the last court date?
Sir,
to verify that?
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case.
Okay, so she's going to send me a packet and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
Don't interrupt me again. We had this conversation before, didn't we?
Sorry.
We had this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accordance with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents, and request.
Clip 6 sets up the second half of the disaster. The narrator explains that even though someone else in the case had a similar situation, the difference is massive. She had 8 years of actual law school training. This guy? He has Google, 2 conspiracy videos, and a dream. Watching him try to navigate court without professional help is like watching someone attempt surgery with a butter knife. Eventually, even he realizes the universe is against him, and he finally accepts the discovery packet. His magical refusal powers fail spectacularly. This first appearance wraps up, and the second round is about to start. And trust me, if you think the first appearance was chaotic, the second one is practically a sequel with a bigger budget and more unintentional comedy.
All right, we are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Taking time for pretrial, your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without.
Clip 7 is short, sharp, and savage. The judge looks at him and says, "Are you going to wipe up all those crayons you just spit everywhere?" That is peak courtroom disrespect wrapped in professional language. It's a roast disguised as a question. The crayons symbolize exactly what we're all thinking. This man's arguments sound like they were crafted during snack time in kindergarten. The courtroom reactions, silent smirks, stiff shoulders, people trying not to laugh, make the moment even better. This is one of those lines that instantly becomes iconic. The judge is no longer pretending to take the nonsense seriously. He's calling it out directly. Clip 7 proves once again, courtrooms are funnier than stand-up comedy when sovereign citizens enter the chat.
Anything else you want to say, Mr. Hurst?
That's it.
All right. All right, where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking
Okay, yeah.
first if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer or to that motion for summary disposition, you must do so within the terms provided in the Michigan Court Rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the...
Clip 8 is where the narrator gives the warning we all needed. Get ready, because this is the fun part. Fun for the judge, not the defendant. And he's right. The defendant serves up an entire platter of nonsense, like a gourmet dish made of confusion, denial, and misplaced confidence. A nonsense pate with a dumb salad side? Perfect description. Every time he tries to explain something, he actually digs a deeper hole. And you can see the judge sitting there with that smile that says, this is going straight into my mental highlight reel. The pacing, the tension, and the slow build-up to the judge's reaction make this clip comedic perfection. You can feel the entire courtroom bracing for impact every time the defendant opens his mouth. This is the moment the video has been teasing, and it absolutely delivers.
The court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? The plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in our request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must, by affidavit or as otherwise provided in this rule, demonstrate the existence of general issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the 3rd page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment.
And finally, clip 9, the grand finale. The narrator admits he replayed this moment at least 10 times, each time smiling harder. That tells you everything you need to know. Whatever happens in the final judge reaction is pure, unfiltered entertainment. It's one of those moments where the judge's facial expression alone is worth the entire video. The outro rolls in smoothly. Like, dislike, comment, subscribe. All the classic YouTube ritual. But the highlight remains the judge enjoying every second of this sovereign citizen meltdown. The sponsor shout-out lands cleanly too, making it feel like the perfect comedic wrap-up to a courtroom roller coaster. This clip isn't just an ending. It's a victory lap for everyone who watched the chaos unfold.